Meanwhile, we're going to, this is the short burst session, and so with not more than hopefully a minute or two, we're going to go into our next presentation with Miss Alexandra Perina from the State Department, is going to tell us talk to us about the legal aspects of the nuclear weapons ban treaty. And, you know, strangely enough, we haven't, historically in our Lens conferences, we haven't done much in terms of nuclear weapons. Alexandra, thank you so much for joining us. And I do want to tell everybody that, should I give the disclaimer, Alexandra, or what makes you most comfortable?
Well, so hi. First of all, thank you for having me here today. My remarks today will reflect actually the U.S. government official position. So that can be considered sort of an official statement. Depending on where we go in Q&A, I might have to offer a personal disclaimer, but I think to start out, I'll be talking about the U.S. government's views.
So tell us about the nuclear weapons ban treaty.
Sure.
Not everybody may have heard of it.
Yes. Well, I should say again, thank you for having me. I certainly wish we could be together in North Carolina right now, but it's a pleasure to be with you virtually this afternoon to discuss the ban treaty, or formerly the Treaty on the Prohibition of Nuclear Weapons, which in my head is reduced to the acronym, the Tpnw. So I may refer to it as that in these remarks. So President Biden and Secretary Blinken have both made clear that the United States has not just a national security imperative, but also a moral responsibility to reduce and eventually eliminate the threat posed by weapons of mass destruction. The United States has long supported the goal of nuclear disarmament, and indeed has undertaken in the Nuclear Nonproliferation Treaty, the NPT, the obligation to pursue negotiations on effective measures toward that end. We see that as an incremental process, progress on which depends largely on the prevailing security environment, and which cannot occur in a vacuum. And that's really exactly why we don't support and won't join the ban treaty. In fact, no state known or believed to possess nuclear weapons does support the ban treaty, nor does any state, in fact, that relies on nuclear deterrence by a treaty ally. So why not? I'll discuss today some of the legal concerns and risks with the ban treaty from the U.S. perspective. I know there's a range of backgrounds in the audience today, so I wanted to spend just a few minutes to set the stage with a brief overview of what the Tpnw actually contains, and then place it in the broader context of disarmament efforts. And against that backdrop, I'll talk about why the United States opposes the treaty and views it not just as an ineffective measure in advancing disarmament, but also as potentially harmful to the existing non-proliferation and disarmament architecture under which genuine progress could be made. So by way of background, the Tpnw was negotiated at a conference convened in 2017 pursuant to a UN General Assembly resolution, and the text was finalized in a matter of mere weeks in that summer. It opened for signature in September 2017, and it has now entered into force as of January 22nd of this year, which was 90 days after the deposit of the 50th instrument of ratification or accession. As mentioned, none of the nuclear weapon states under the NPT, the United States, UK, France, Russia, and China, or any of the states known or believed to possess nuclear weapons participated in those negotiations. So what does the treaty prohibit? It prohibits all parties from developing, testing, producing, otherwise acquiring or possessing nuclear weapons or other nuclear explosive devices, from using or threatening to use nuclear weapons, from transferring or receiving nuclear weapons, including control of such weapons, from allowing the stationing or deployment of nuclear weapons in the territory or under the jurisdiction or control of a state party. It also prohibits parties from assisting, encouraging, or inducing anyone to engage in activity that's prohibited under the treaty. The treaty, of course, allows for states without nuclear weapons to join, but it also permits states that still have nuclear weapons to join prior to eliminating their nuclear weapons, notwithstanding all of the prohibitions that I just mentioned. many of which are obviously incompatible with possession of nuclear weapons. With respect to safeguards and verification, the treaty's requirements differ depending on the status of the state party. So it defers all significant disarmament verification requirements for resolution in the future with undefined terms and through undefined mechanisms. And I'll come back to that later. The treaty requires state parties to take appropriate national measures, including penal sanctions to prevent and suppress activity prohibited by the treaty. And it includes provisions that require assistance to victims of nuclear testing and environmental remediation. It also includes, I'll just note, a withdrawal provision that requires states parties to give 12 months notice of withdrawal, and it provides that withdrawing parties must remain bound even after that 12-month period for so long as the state is a party to an armed conflict. So what are the key concerns with the Tpnw? Well, first, it purports to position itself within the NPT framework. It refers to the NPT in the preamble as the cornerstone of the nonproliferation and disarmament regime, although it misstates the NPT's obligation on disarmament. But in fact, it dispenses with some of the key balances that make the NPT work. So, for example, a central policy criticism of the Tpnw is that it doesn't take into account the international security environment in which disarmament must occur. Whereas the NPT recognizes that, quote, the easing of international tension and the strengthening of trust between states, end quote, would facilitate disarmament, the Tpnw doesn't acknowledge or reflect that relationship. The NPT nuclear weapon states have made clear that complete disarmament in the current security environment is simply unrealistic, and that progress on disarmament is necessarily tied to improvements in international security, which requires a more gradual approach that builds on successes. Moreover, the NPT rests upon three pillars: nonproliferation, disarmament, and the promotion of peaceful uses of nuclear energy. But the Tpnw fails to acknowledge the critical interrelationships between these three objectives. The NPT recognizes, quote, the inalienable right of all the parties to the treaty to develop, research, production, and use of nuclear energy for peaceful purposes without discrimination, and this is the important part, in conformity with, which is therefore conditioned on, their nonproliferation obligations. But the Tpnw in its preamble emphasizes the same right to develop nuclear energy for peaceful purposes, but omits the link to nonproliferation obligations. Similarly, the Tpnw seeks to advance disarmament without commensurate progress on nonproliferation. And in particular, it adopts the nonproliferation safeguard standard of the 1970s and overlooks the critical efforts to strengthen those safeguards with new standards that began in the 90s. Instead, it prioritizes progress on disarmament at the expense of nonproliferation in a way that I'll turn to now could distort and undermine the existing nonproliferation framework. So with respect to nonproliferation verification under the treaty, as mentioned earlier, the nonproliferation safeguards required by the Tpnw vary depending on the status of the state party. So for those states parties that did not have nuclear weapons as of July 2017, it sets out two possibilities. The first is that those without existing safeguards agreements must enter into, at a minimum, the Comprehensive Safeguards Agreement with the IAEA, which is the current standard required under the NPT to assure the non-diversion of nuclear material from peaceful purposes to weapons. The other possibility is that those states that have existing safeguards agreements in place with the IAEA must maintain those safeguards. And this would require those states that have concluded an additional protocol to the CSA, which is aimed at verifying the absence of undeclared nuclear material and activity, to maintain the AP as well. So this sets out a differentiated and static standard between non-nuclear weapon states that have adopted the AP already and those that have not. This was a political compromise during the Tpnw negotiations designed to accommodate key Tpnw proponents that don't have APs. And importantly, it could undermine the safeguard standards in the NPT, which is widely viewed to be evolving, and for which a combination of the AP, the CSA, and the AP is already widely recognized as the de facto standard. The Tpnw sets out yet a different requirement for any state party that had nuclear weapons as of July 2017. So such a state would be required to have safeguards, quote, sufficient to provide credible assurance of the non-diversion of declared nuclear material from peaceful nuclear activities and of the absence of undeclared nuclear material or activities in the state as a whole. That's an indirect reference to both the combination of the CSA and the AP, the Comprehensive Safeguards Agreement and the Additional Protocol. So perhaps most concerningly, the overall result of the Tpnw's differentiated requirements is that a state like Iran, which is a non-nuclear weapon state under the NPT and does not have an additional protocol in force, although it has been applying it provisionally, would be required under the Tpnw to accept a lower standard of non-proliferation safeguards, only a Comprehensive Safeguards Agreement or CSA, than the United States would if the US were to accede to the Tpnw. That kind of stratification seems almost certain to lead to mistrust among states parties by leaving open the possibility for precisely those states that have been reluctant to adopt the AP to date to pursue clandestine nuclear programs with a lower likelihood of detection. With respect to disarmament verification, the Tpnw's approach seems equally ill-suited to the realities that nuclear weapon possessor states considering disarmament would face. So to begin with, the Tpnw deferred the challenging issues of how to effect and verify disarmament in favor of fairly vague and broad requirements. Under the Tpnw, a state party that possesses nuclear weapons must immediately remove those weapons from operational status and submit a plan for the verified and irreversible elimination of such weapons within 60 days. This plan, which would be legally binding and time-bound, would be negotiated with a, quote, competent international authority that is yet to be identified and designated under the treaty. The plan would then be submitted to other states parties for approval. So in other words, the ban treaty seems to contemplate that states possessing nuclear weapons would join the treaty with the details of disarmament, including verification, to be worked out later. Its provisions offer, at best, a sort of notional roadmap rather than a detailed system for disarmament and verification. And it's simply hard to imagine that any nuclear weapon possessor state would agree to join the treaty without the details of such undertakings being carefully negotiated and settled in advance. The meeting of states parties would be empowered to make decisions about these matters under its rules of procedure that do not necessarily guarantee acceding nuclear weapons possessors the ability to protect their national security interests. And it's worth noting that the verification of disarmament is really no small task. One example that's often given is that of the New START Treaty. The New START Treaty contains 10 lines of text that set forth its central limits, and then 356 pages of detailed text addressing a verification system that make those reductions achievable. A disarmament plan and verification apparatus for an entire nuclear arsenal is a tremendous undertaking and one that would require extensive negotiation of separate instruments and would need to address also the concerns of nuclear weapon possessor states that disarmament verification activities would not themselves become an avenue for proliferation. So given the obligation of nuclear weapon states parties to the NPT not to assist any non-nuclear weapon state acquire a nuclear weapon, there would be serious questions about who would be competent to verify such disarmament and whether the Tpnw's designated competent international authority, whoever that may ultimately be, rather than other NPT nuclear weapon states, would be in a position to do that kind of verification. So in sum, the ill-defined approach to disarmament in the treaty departs so fundamentally from the key arms control and verification practices that have been developed through painstaking negotiation in current and previous arms control agreements that it's really difficult to imagine that any state possessing nuclear weapons would rely on the Tpnw as the basis for its own nuclear disarmament. I wanted to make one last point about the NPT, which is that the Tpnw could undermine the NPT insofar as it could expressly supersede it where there may be conflicting obligations. Although, as I've mentioned, the Tpnw pays lip service to the NPT as the cornerstone of the non-proliferation and disarmament regime, Article 18 of the Tpnw provides that in the event of a conflict between the Tpnw and a pre-existing treaty, like the NPT, the Tpnw would prevail for states that are party to both treaties. Although the Tpnw obviously can't affect the rights and the obligations owed under the NPT to states that are NPT parties alone, it could lead to interpretive conflict. And so the United States has completely rejected the idea of subordinating the NPT to the Tpnw. And notes that to the extent there were to be a conflict, Article 18 of the Tpnw could not and does not affect the obligations owed by a Tpnw state party to an NPT state party that has not joined the Tpnw. There are some potential implications for other legal relationships outside of the NPT framework. The Tpnw could have impacts in other areas, especially since its basic obligations seem to be incompatible with nuclear deterrence, including nuclear mutual defense alliances such as NATO. So as noted earlier, the Tpnw prohibits states parties from using or threatening to use nuclear weapons and from assisting, encouraging, or inducing a state from engaging in such conduct. So these obligations taken together would appear to preclude a state party from participating in a defense alliance that's predicated on nuclear deterrence. The Tpnw also prohibits a state party from allowing any stationing, installation, or deployment of nuclear weapons on its territory or under its control. That would prohibit nuclear basing arrangements. And notably, again, no non-nuclear weapon state that participates in a defense alliance backed by nuclear deterrence provided by a nuclear armed state has supported or joined the Tpnw. In addition, some Tpnw states parties have already indicated that they interpret the prohibition in the treaty on aid, inducement, and encouragement to preclude even transit or overflight of nuclear weapons through their territory under their jurisdiction. That's despite the fact that an express prohibition on transit was considered and rejected during Tpnw negotiations. So given that it's US policy neither to confirm nor deny the presence of nuclear weapons at any specific location, including on US ships or aircraft, measures adopting such an interpretation could have broad implications for US military activities. So the vague and disputed scope of these prohibitions also raise questions about whether defense cooperation by Tpnw states parties with non-nuclear weapon states that are under a nuclear umbrella could be viewed as prohibited as well. So for example, could a Tpnw state party export equipment for use by the armed forces of a state allied with a nuclear armed state? Or would such engagement be potentially viewed as encouragement of or assistance to activities prohibited under the treaty? It's worth pointing out that these prohibitions on transfer or control of nuclear weapons, when combined with the broad prohibition on providing or receiving assistance to such activities, would also appear to preclude a Tpnw state party from assisting in the removal of nuclear weapons from other states. So this has been a critical role that NPT nuclear weapon states are able to fulfill consistent with their NPT obligations. If, for example, the NPT nuclear weapon states were to join the Tpnw, the treaty's prohibitions would appear to not only impede, for example, efforts to denuclearize North Korea, but also prevent them from either providing or receiving assistance in a crisis situation involving terrorism and a nuclear weapon. In terms of implications for private citizens and entities, the Tpnw requires its states parties to take, quote, appropriate national measures to prevent and suppress activity prohibited under the treaty undertaken by persons or on its territory under its jurisdiction or control. So how states parties implement this provision will be something to watch closely because it could entail significant risks for individuals and private entities as well, such as banks that work with NPT nuclear weapon states and their allies. Similar provisions requiring national implementation measures in other treaties like the Ottawa Treaty, banning landmines and the Convention on Cluster Munitions, suggest that this provision could be widely interpreted to require measures prohibiting and sanctioning financing of activities prohibited under the treaty. The United States would urge TPNW states parties and any state considering becoming a TPNW party to consider really carefully the implications of the scope of any national measures that they adopt, including the possibility that such measures will have even broader impacts than might be intended if states, other states and private entities sort of de-risk by limiting their engagement with such states. And finally, I wanted to make one last point about customary international law. There have been a number of other legal criticisms and questions about the TPNW, but the last one I wanted just to raise in these remarks relates to the relationship between the treaty and customary international law. There have been efforts to promote the treaty as contributing to the development of a new rule of customary international law that prohibits the possession of nuclear weapons, perhaps seeking to bind nuclear weapon possessor states indirectly in recognition of the fact that they appear not to be joining the treaty itself. And the United States has firmly rejected any claim that the TPNW reflects or could contribute to the development of such a customary norm. It's simply unsupportable, really, under international law, although that doesn't mean it won't create sort of confusing and distracting arguments. To just explain this a little further, customary international law is evidenced with two features. First, the general and consistent practice of states, including specially affected states. And second, opinio juris, or the belief that the practice is required by an existing rule of law. In the case of nuclear weapons possession, of course, none of these elements exist. In practice, states do possess nuclear weapons, and those states would be considered to be specially affected. They do so largely subject to treaty regimes like the NPT that recognize such possession. And any prohibitions on nuclear weapons possession are expressly treaty-based, like in the NPT or in nuclear weapon-free zone treaties, rather than reflecting a widespread custom under international law. Moreover, the TPNW itself is inconsistent with the creation of a norm of non-possession of nuclear weapons, insofar as it doesn't actually prohibit states from joining the treaty while they still have nuclear weapons. Instead, it contemplates that such states would relinquish their nuclear weapons at an unspecified future date under unspecified future circumstances. And so it should be no surprise that the NPT nuclear weapon states and their military allies around the world have consistently and openly opposed the idea that the TPNW advances in any way customary international law. So just in closing, I would say that it could be easy to be cynical about the nuclear weapon states' rejection of the ban treaty and try to suggest that it reflects a lack of commitment to disarmament. But a closer look at the TPNW, I think, reveals that it's simply ineffective in advancing its cause because its prohibitions are vague and broad and present these questions about how its implementation will impact productive international cooperation among states. At worst, it threatens to undermine states' cooperation under the NPT, impede progress on the developing standards of nonproliferation verification, and divide states that do have a common interest in promoting disarmament. The United States, of course, remains committed to advancing nonproliferation and disarmament goals of the NPT, as well as increasing cooperation on the peaceful uses of nuclear energy. And I would just mention that 2 weeks after President Biden took office, the United States and Russia have extended the New START treaty for 5 years. That's the kind of arms control decision that, in the US view, makes the world safer, and was really the beginning of sort of renewed efforts in this administration to address nuclear threats. So I will stop there with that introduction, and I'm happy to have more of a discussion and take any questions.
Well, we have a number of questions. I thought I knew something about the treaty. I realized I did not because there's a lot more implications to it than I realized. Let me just try to grab a few of these questions. Bill Boswell asks, which states are pushing the new treaty and why? And what do you think their agenda is, if you can say? And Sherry Shang, and apologies if I butchered your name there, but she says something related to it. Given the significant disagreements, what common ground can nuclear and non-nuclear states use to keep all sides at the negotiating table? And just to make it particularly hard on you, Alexandra, we have another question from Kaylee Walsh, who raises what are the implications to the with Palu, who is a party to, and will it damage the renegotiation of the treaty or agreement of free association with that end?
Sure. Okay, so I would say in terms of the first question, or maybe the first two together, you know, I think it's right that the treaty was driven by states that are really frustrated with the pace of nuclear disarmament. It's really a message, and including the fact that it went forward without the participation of nuclear weapon states. I think that it really is a message about this frustration and this impatience. In terms of the particular states, you know, there's 50 of them now who have joined. I would need to look at the list. I believe it was the 50th that got over the finish line. I want to say it was the Bahamas, but I may be wrong about that. So I'll just set that to one side. But I think the recognition of frustration is something that the United States and nuclear weapon states do understand. And I think the answer to that is needing to start with the recognition that, again, disarmament can't occur in a sort of vacuum. And that it's challenging precisely because for nuclear weapon states, it's tied to the global security environment. So in terms of how you move forward, the United States has really tried to pursue practical approaches to disarmament that address those kinds of realities. You know, I mentioned the New START agreement that was just extended. I think the United States Secretary Blinken addressed the conference on disarmament in Geneva earlier this week and emphasized the importance of resuming a range of efforts to advance that goal, including, for example, by negotiating a treaty to ban the production of fissile material for nuclear weapons. But in terms of sort of common efforts that can bring nuclear weapon states and non-nuclear weapon states together, the United States has pursued a number of kinds of initiatives. One is called the initiative of creating an environment for nuclear disarmament, the CEND. It's a working group that's brought together about 40 countries over the last couple of years, including all the NPT nuclear weapon states and other nuclear weapons possessor states. And it addresses really the need to improve the security environment to facilitate progress. So its working groups have considered, for example, how do you in a real way reduce the perceived incentives for states to retain, acquire, or increase their holdings of nuclear weapons? And how do you increase the incentives to reduce or eliminate nuclear weapons? Another example is the International Partnership for Nuclear Disarmament Verification. And that's a group that's a public-private sort of cooperative effort. It's convened more than 100 experts from 30 countries, and it examines sort of potential solutions to the many real concrete challenges associated with future nuclear disarmament verification. So in exactly the kind of concrete specificity that the Tpnw avoids. One example is that the partnership has considered what kind of multilateral verification is possible for disarmament of a nuclear weapon, and concluded that while challenging, some kind of multilateral verification should be possible, while protecting proliferation sensitive information and accommodating safety and security requirements. So I think our hope is that the Tpnw won't become a sort of distraction that will be polarizing among states on these issues, or lead to a loss of attention from this kind of more practical, concrete work, or misdirect sort of energies away from those projects that we view to be more promising avenues. On the question about Palau, was that the third?
Yeah.
Was that the third one? So I would have to refer you to sort of our regional experts about the details of the compacts. My understanding, though, is that the nuclear deterrent does not extend to Palau. And that's a situation where, although we have a sort of defense alliance with them, it would not implicate the nuclear umbrella in a way that some of our other alliances would. And that those states that rely on the nuclear umbrella are the ones that continue to oppose the ban treaty.
Gabby Levico, who's a Duke Law student here, she asked, can you talk a bit about how the Tbnw affects U.S. goals for addressing the threat of North Korea and Iran?
Sure. So how does it affect our goals? I mean, so the Tpnw is now in force, right? And a couple of things about that. I mean, first, as I mentioned, because no state possessing nuclear weapons, including the United States, has joined, the entry into force doesn't affect U.S. nuclear weapons, U.S. nuclear weapons policy, nuclear U.S. Obligations under the NPT. So in terms of the U.S. legal posture, it wouldn't affect our ability to sort of work with North Korea or Iran on nuclear issues. I think, as I mentioned earlier, there is this prohibition in the Tpnw that if the United States were a party, or any NPT nuclear weapon state were to become a party, could problematize the effort to assist in nuclear disarmament, because you would be prohibited from, receiving a nuclear weapon or receiving transfer of a nuclear weapon. And so you'd have a question about how do you actually affect nuclear disarmament in a state if you're under that kind of ban.
Alexandra, we are unfortunately again running out of time, and I do invite everybody to look at your very impressive bio. But while I do have you here, I have a lot of students who would love to be you. I mean, could you tell us a little bit about your journey to the State Department, and maybe some advice you might have for those? Some of them are military lawyers, some of them are law students, some are other kinds of practitioners, and on how they can become Alexandra.
I'm not sure that should actually be the goal, but I will say that the State Department has been, in my experience, just a really fun, wonderful place to work. I've been now in the State Department legal office, which is known by its acronym L, for 15 years. And I've done a lot of different things in that time. I came to the State Department after 2 years in private practice following law school. So really the vast bulk of my sort of adult life as a lawyer has been here. So it's largely what I know. A couple of things, though, about life at the State Department. Well, maybe I'll back up and say, just in terms of how I got here, and to the extent that sort of influences people thinking about whether they're the right kind of person for here. I grew up in a State Department family. I should acknowledge that. My father was a career diplomat for 35 years. So I grew up in State Department communities, abroad, moving around every couple of years. And that's all to say that I was just familiar with the work of the State Department very early on, and the kind of public service that's done in the U.S. government on behalf of its employees. So I was always sort of aware of it growing up. I didn't necessarily expect that I would end up here, but in law school, I had a great interest in international law. I pursued that in private practice for a couple of years, and then decided that I wanted to sort of join this office, see how that worked out. One thing I think that's important for people to understand if they're considering the State Department or thinking about what it might be like to be at the State Department is that by and large, the attorneys in the legal office here, I think there's about 250, 300, something in that range now, are generalists. So you join the legal office and the bureau as a whole, and you can be put, you do not know when you join necessarily where you will be put as a generalist, and you are assigned to an office. So the State Department legal office does everything from kind of in-house general counsel work, doing management issues, doing employment law, working on FOIA cases, congressional liaison work, to litigation with the Justice Department, litigation before the International Court of Justice and other international tribunals, to, of course, a lot of the multilateral and bilateral treaty work that my office does and other offices do as well. So you don't really know where you're going to end up. And the model is sort of modeled on the Foreign Service, which is that you rotate around every, say, 2 to 5 years into different substantive areas. So it's important to think about whether, you know, if you decided you want to be in public service and work on some of these really fascinating issues that I think you can do from a very special position within government, you know, is there sort of one niche issue set that you want to be involved in for sort of the duration of a career? Or are you comfortable sort of throwing yourself into the mix and doing, so since I've been at the State Department, I've done employment law, environmental law, what we call political military affairs, which is law of war and cyber and other things. And now just for the last sort of 2.5 years, I've been doing nonproliferation and arms control. So there has to be, I think, sort of an interest in being, and a comfort level of being a generalist in that sense. If you're thinking about coming to this office. I should say there's a couple carve-outs. There are a few offices where there are specialist attorneys. So for example, in employment law and investment claims and disputes, in consular affairs, we have a cadre of sort of specialist attorneys, but by and large, it's kind of a generalist model here.
I'm afraid we only have a chance for one more question. And I do want to do a little follow-up because I get asked this sometimes and I really don't know the answer. Do you think is there a direct path, I mean, law school into Department of State, or is it better to go to the firm and go from the firm, or clerk, go to the firm, then go to state? What are your thoughts? Just your personal opinion.
So yeah, so I came in as a lateral after 2 years in private practice, as I mentioned. L also does have a summer program and it has externship programs. So there are people who will get some experience working here while they're still in law school and then come directly after law school or after a clerkship. I am not on the recruiting committee, I will acknowledge that, but I know many people who are. And I will say that there's really a range. I don't think there's any one silver bullet to winding up here. I think probably more dispositive than, you know, whether someone has, you know, had a particular kind of experience is just to show that they've really been passionate about and have excelled in whatever the experience is. I would note that I think also it's not necessary to have specialized in international law before you get here. Like maybe many government offices, you know, a lot of their real core training is sort of on the job. I think it's probably more important just to show that you've taken on challenging opportunities in whatever area you've been working in and interested in, and to show how you have excelled in that kind of context. And the assumption will be that your talents and your energies and your dedication is transferable to a different area as well.
Alexandra, I really can't thank you enough for taking time out of your schedule. Like I said, I thought I knew a fair amount about the treaty. I realize I don't. So it's really been enlightening. And I think you have some messages there that we need to get out, because it sort of appears that the US just doesn't care about nuclear proliferation, or we just want to have bombs. And that very much, as your presentation illustrates, is not the case. But as valuable as that, I think these last few minutes when you shared a little bit of your personal story, I really appreciate that. And I think others who are many students and military lawyers and other lawyers and the general public find that fascinating. And we do have a connection. She went to Haverford College. Guess what, audience? I think it was a different era. I don't think she was even born when I was interfacing with Haverford, because it was then an all-male college. You might, well, you don't remember. But thank you again, folks. We'll be back in 10 minutes and see you then.
Thanks so much for having me.